Hello friends, welcome back. Today we are going to learn something very interesting that's about patenting in India. This entire video is pertaining to Indian patenting conditions and I have tried to grasp all what is possible to provide you the complete information about what are all the things that you need to know, how does a patent filing process work. All these things are very clearly made in this session. I hope you will definitely like it. I request all the patent aspirants to listen to it very clearly. Normally, it is seen that the Indian patenting as a very tough task. It's easier actually, and there are guidelines. Follow that, and you will get your patent filed and granted in a very smooth way. We have a process, we have a flow, and a structure. Let's patent it by following those. And people who do not know it only end up with getting a lot of issues and challenges. But once you understand these, I think it is easier. It is not as difficult as we all think. Well, what are all the stages in patenting? Let's go with the process. I'm going to go step by step, one step at a time. Let's go by that. First is patentability search. I'll explain you all these in a very neat way. The second stage is filing the patent request. The third is patent publication. The fourth is examination of the filed patent request. Fifth is disposing. Either they can grant it or they can reject it. Sixth is renewal. You need to go for a renewal as well. It starts with patentability search, it goes with filing, then you need to get your patent published. It happens automatically, or you can go for early publication. Then you need to request for examination. Then once it is over, you will get your patent either granted or rejected, and then you can go with renewal. Can we go with stage by stage? We will understand each of this. First is patentability search. Well, this is where you can understand if your invention or finding is worth to be filed as a patent request. As per 1970 Patent Act, Government of India, we can analyze if our invention can be granted a status of patent. This is like analyzing the literature when you start working on a research project. You can look at the non-paid databases which has got the collection of most of the previously available patents, which include United States Patent Office, World Intellectual Property Organization, Japan PO, Google Patents. All these will come into picture and you can analyze, and they are non-paid. Please remember, there are some paid databases as well, but this could be sufficient for somebody to understand if the invention that they have in mind, if the invention that they have drafted in hand is new, novel, or is already available. So this can be analyzed. This is called patentability search. Now, the patent database is what is discussed recently, and now we need to also understand what is non-patent databases. You can analyze the patent databases like US Patent Office, Japan Patent Office, all those things, but there are non-patent databases which include the journal publications like the IEEE papers, the ACM papers. All these things are to be as well analyzed to understand if your invention qualifies to be filed as a patent. Most of the patents are already published as a paper, and if the analysis is not done properly, it's going to be a problem. And remember, within 1 year of the publication of a paper, you have written a paper and you want to publish it as a patent, you want to go ahead with it as a patent, you got to do it within 1 year of the publication. Otherwise, it's not qualified. A well searched, well analyzed submission has a higher chance to get through as a patent. This is called prior art check. Remember, this is called prior art check. So the patentability search include two parts. One is patent databases, the second one is non-patent databases, and that's what we have seen. Now we will go with the second very important stage. What is it? Filing. Filing can be done in two ways, and they are called provisional and non-provisional filing. But before that, please understand, you can file a patent as an individual, that is called a natural person, or you can file it belonging to a small entity, or you can file it from an organization which is huge like large entity. So you can take up any of these three options and fees will be varied according to the choice that you have made. The first one is provisional filing. We have got two types of filing. One is provisional filing, second one is non-provisional filing. The provisional filing is provisional nature, which means that you are filing only the idea, the problem focused, the field, the title, etc. This is like a very preliminary submission, and you are telling them what you want to do and what is the field that you work on. All those things will be very brief, and this is called provisional. It is not complete. Now coming to the next one, non-provisional filing. The non-provisional filing is the one we call it as complete filing, and this is a complete submission and has all the details. It has to even include the claims. Claims will define your invention. Please understand, the claims are part of your patent filing process and they define your invention. Minimum 10 claims can be there for Indian patent submission, but it can be maximum up to 200 even. But each additional claim that you put over and above the 10th claim will cost you 320 rupees in India as of now. There are two types of claims. One is system claim that talks about the machine, the structure. Second one is the process claim, time bound components. The time bound content will all come under this process claims. So remember it. This is very, very important. Now let's come to the provisional filing further. What is it? If you opt for the provisional filing, you should go for the completion as well. I mean, you need to go for the complete filing, the non-provisional one as well. You need to submit all the data before 12 months from the provisional filing. If you have only filed the provisional submission, you need to complete it within 12 months. This is very important, and filing can be done as the ordinary submission or conventional or patent of addition. Ordinary submission is very normal, that's how you and me do. Conventional submission will enable you to file in India, and then later on you can go ahead in other countries. 273 other countries have got their own patenting structure and you can follow it and you can do it. Then patent of addition. I have already got a patent. I am going to add something more to it and I am going to enhance that product or idea further. So that is called patent of addition. I have something in hand, I am going to enhance it, and that's called patent of addition. But make sure that your patent of addition is not going to nullify what you have claimed in the first submission. Otherwise it's not legal and it's not acceptable. So now before filing, you need to have three very important things in your mind. The first one is novelty. How much your idea, how much your invention is novel, is fresh. Inventive step, what are all the methodologies, what are all the process that you are following to make sure that your invention is novel. What is the flow that you follow is very important. Then industrial applicability, the societal usage and the industrial reproduction, commercial viability, all those things will come into picture here, and these three will make sure that your patent, your submission is granted a status of patent, and all these should be coming under section 2 of 1J, and once the conditions in that section are satisfied, we can go ahead with the submission, and that's how it works. Now the next state is publication. What are all the states that we have discussed now? As you could see, we have completed the process of patentability search, then filing, and now comes the publication. We need to see that, followed by that we will go with examination, and then it's going to be pretty easy for us. Let's go ahead with the patent publication. All the patents which are submitted gets published. Yes, this is done as a part of the process, and publishing a patent doesn't guarantee you that the patent will get granted finally. It is a process and it will happen. It can be published in a normal flow which will take 18 months, or it can be published in a faster flow which can happen in 14 days. That's called early publication request. And why do we have to publish a patent? Why this process followed? Very simple. This enables anyone to see what are all the patents that are published, and in case somebody has used some other patents already, they can raise an objection to the intellectual property appellate board, and this can help them in identifying the problem. Also, after publication, pre-grant, post-grant, an objection can be raised, and there is absolute protection for your invention. Your intellectual property will be respected. The next stage is examination. This is the most important stage, as I have put in there in the presentation, and this is called FER. They will get you a first examination report, and it could come anytime after 20 months. 20 months could be a variable here. It can happen in 22, 20, and if you're very lucky, it can happen even earlier. Once the FER comes, there could be some questions or some queries or clarifications which you need to reply, and the reply has to go within 6 months, and appropriately it has to be filed, and there could be a hearing after that. In the hearing, you got to explain what your product is all about, what your invention is all about, the flow, everything has to be explained. 30-minute slot will be given to you. And once the hearing is over, they could dispose the patent by granting it or by rejecting it. If your patent request is really novel, is really value add, is really good for the society and has industrial applicability, after the hearing, it would be granted. Some cases, even without hearing, it gets granted, and that has to be really very strongly filed. Now, renewal. This is the last stage in the entire process, and a patent is 20 years valid. Remember, a patent when you file, it's with you for 20 years, but it has to be renewed. after the grant, the first 3 years, there is no fee for renewal, but fourth year onwards, you've got fees, and you can get all this detail from the patenting website. Now it is time for us to understand the forms. There are multiple forms that are connected to the entire patenting process, and I'm going to talk about it right now. Form 1 is nothing but the application for the grant of Indian patent. This will have the details of the applicant name, the address, the affiliation, title, contact information, all these things, and this has to be definitely filled very carefully, because changing this information will cost you and there is a fee connected to it. Form 2 is provisional or complete specification. If you are going with the provisional selection, it's a very simple way. You need to just give a small piece of information that talks about your invention. That's what I told you some time back. Provisional is simple, but complete is going to be a really large submission, and you need to have the title, the field of invention, the background of invention, the aim, summary, brief description of the drawings, detailed description of the drawings, claims, abstract. All these are to be included in the prescribed format in the prescribed order. Please make sure that you go through the guidelines that are given, because abstract cannot be more than 400 words. Likewise, they have given some restrictions, and please follow that meticulously. Form 3 is nothing but undertaking. This is where you are confirming that the invention is yours. Form 5 is declaration. Form 3 is undertaking. This is where you confirm and agree that the patent has not been filed in any other country. And Form 5 is all about declaration. You say that it is all yours. Form 9 is earlier a publication request. If you want to go for 14 days publication option, you need to pay a little more fee, higher than normal fee, and you will get it published, but otherwise it's normal flow, which will come in 18 months. And Form 18 is nothing but request for examination. This is where you can request the patent officials to come and check your patent, and they will go for the grant or rejection based on this request. There is a Form 18A which is available, which is called yearly grant request, and it will happen within 1 year. The grant is supposed to be happening within 1 year, and there are fee implications which are available over here, which could be really higher. Now, what are all the fee structures? You can get all the details about the fee structure in this link, ipaindia.nac.in/write re-add data/portal IPO form upload and 1_11_1 fees.pdf. There is a document which is available which gives you all the data very clearly, and you can file the documents, you can submit the forms either, you can pay the fee for the forms either online or offline. But offline, when you do, there is a 10% more fee that you need to pay. And when you are filing itself, you need to tell how are you filing the patent as. Are you filing it as a natural person, which is individual, or a small entity or large entity? Natural person is the cheapest mode that we can go with. 1,600 rupees Indian money is what you need to pay. And small entity 4K approximately, large entity it is 8K, and 10% more is what you need to pay if you prefer paying offline. This is very important information, so please make sure you know it. And Form 2, no fees. Form 3, no fees. Form 5, no fees. Form 9, fees there. Please refer the information in ipaindia.nac.in. I hope this helps, and this was a complete process that I have curated towards understanding how the patent can be filed, and I hope you liked it. In case you have any questions, please go ahead and type it in the comment section. I will be able to answer it. And most importantly, if you like the channel and the content, please subscribe. Thank you very much, and hope you are all safe. Thank you.